Thank you, Simone, and good afternoon to everyone. Kalispera to Mr. Perakis. I also see some familiar faces. It's indeed a pleasure to be here with you today. Also, many thanks to a very comprehensive, clear presentation on the RRF from colleagues from SG Recover. It is a task force indeed. So if you just excuse me for 1 second while I try to share my few slides.
Yes.
Can you see them?
We see them very well, yes.
Excellent. All right, so following this very useful and broad presentation on the opportunities under the RRF, I would like to zoom in a bit with regard to issues pertinent to digitalization of justice, or Ejustice as we call it. Now, we, of course, renewed our efforts in 2020 in the context of the COVID-19 pandemic for obvious reasons, but digitalization of justice, as perhaps many of you know, is not new. National authorities have been working towards the digitalization of their justice systems for a long time, really, and some member states are very much advanced, others not so much right now. But against the background of the pandemic, it really became essential that we renew the work in this regard with doubled efforts, because the pandemic not only highlighted the need to move to more efficient and effective justice systems, it was really a stress test. Without digital solutions, we would not be having this meeting today. So it's really a matter of resilience. And the crisis has also put into question the very concept of rule of law at some point during the worst of the lockdowns. In fact, there were a number of exercises last year to take stock of the effects on justice systems as a result of the crisis. But I don't want to go further into this because you as practitioners probably know better than myself how it affected your life and your work and the work of the judiciary. So before I go into details, let me just summarize our key deliverables on the side of Justice and the Commission last year. On the 2nd of December, we adopted a very comprehensive package of initiatives with regard to modernization of justice. The first element is the communication on digitalization of justice in the EU, which was adopted together with the staff working document. With the so-called digitalization mapping. If you have not had a chance to look at this mapping, I would invite you to. There are links later on in my slides. But essentially what we did during the summer months, also with the very kind collaboration of the CCBE and the bar associations and law societies of Europe, is that we did quite detailed work to identify the state of play when it comes to digitalization of justice. We have circulated a questionnaire also to the bars, and I thank you for your contributions in this regard. As a result, we have this document, which is about 70 or 80 pages. I'm not quite sure, but I think we have about 100 questions. We have asked national authorities and stakeholders such as the notaries and the lawyers to gather their input as to how far advanced national justice systems in all EU member states are. Secondly, we also adopted a legislative proposal on the IT system called e-Codex. Some of you I know are familiar with it, but I'm not going to go into detail for the purposes of this presentation. And last but not least, of course, the Commission adopted the European Judicial Training Strategy Forum, and I think I might have the date wrong here. All right, so let me take a bit of a pragmatic approach to Ejustice, though, because I think it's important that we establish a bit of a baseline of what Ejustice is about. Now, the first element here, I don't think I need to go into details. Obviously, we are very much reliant these days on video conferencing, such as this Teams platform you're using today, not just for this sort of meetings, but also in the context of judicial hearings, for example. When it comes to interviewing witnesses, experts, when there is a need to communicate remotely, also with detention facilities and so on and so forth. Secondly, there is the opportunities offered by use of electronic tools by judicial authorities and practitioners, be that electronic case management systems or any sort of electronic channels for secure data exchange, such as, for example, submitting evidence from the police to the court or a claim from a lawyer to a court and vice versa. Then we have the various digital public services in the area of justice. These are, for example, the various public registers which provide easy access to information, for example, on businesses, on land plots, or more restricted kind of systems which would allow, for example, citizens to obtain an electronic criminal record where that's allowed, because I know the legal situation is also evolving, and this is part of the reform, because access to public documents obviously is a field where citizens and businesses have a high interest in. Being able to have a legally valid birth certificate, this is a possibility in some member states, not in all, unfortunately. Electronic service of documents is also a developing field. On the EU side, just last year we have adopted 2 new regulations which in fact make the service of documents and taking of evidence in civil and commercial matters mandatory the use of the digital channel. So the regulations have been adopted, but of course this concerns only the cross-border communication. Another example is the online publication of case law with the objective to ensure better transparency, with the objective of ensuring better access to case law, the uniform application of EU law based on national practices, and also with regard to the publication of case law as open data, which is really the fundamental, also building solutions based on artificial intelligence, for instance. And talking about artificial intelligence, of course, there is the entire discussion, and because obviously AI has reached the justice field as well. We are also working in this direction, and member states as well. There are already quite a few national good practices when it comes to use of AI solutions for anonymization or pseudo-anonymization of judicial decisions, for example, to make them GDPR compliant. The use text or text-to-speech applications, for example, to generate automatically a transcript of a hearing, process automation for improving the efficiency of workflow, document management, workflow processing, etc. Of course, there is this whole debate we have now going on in Europe on the use of AI for predictive justice purposes, and there are a number of considerations there, but again, I'm not going to go into that right now. Now, coming back to our communication, well, this is this document, first of all, sets out our strategic vision for what the future of digital justice should look like, and more importantly, where the priorities should lie, both from the perspective of EU action and at the national level. And the communication itself is built around 3 main pillars. One of them being that it takes stock of the various financial mechanisms which we hope member states will benefit from to move forward with modernization and reform. Now, here I would like to take a bit more detailed look at the digitalization mapping. As I've already mentioned, it is quite a comprehensive overview of the state of play when it comes to digitalization of national justice systems. And we did consult a very large constituency in this regard. Here you have a link to the mapping if you're interested to see where your country stands in this regard. And we will take this forward. This was not a one-time exercise. In fact, as you may know, digitalization of justice has been monitored through our EU Justice Scoreboard, but the elements which have been included so far were limited. And in fact, as of this year's edition of the Justice Scoreboard and going forward, we will be taking a very detailed look to track and monitor how digitalization of national justice systems progresses. Now, let me give you a few examples based on this mapping. This is based on the replies we have received from the bar associations, the 16 bar associations and law societies of Europe. So here, for example, we compare the use of video conferencing and whether video conferencing facilities exist which allow lawyers to fully carry out their work. So according to the answers, and again, I need to open a bracket here because all these answers are very much high level, so I'm sure a lot of caveats exist. But in 5 member states, this is apparently possible. In 2 member states, lawyers are able to use video conferencing in most aspects of their work, and in 9 member states, they're limited in this regard. This doesn't really give you the answer why, but it still allows for a good high-level tracking of the state of play. Then another 2 questions I have included here, and this is, by the way, certainly not how you do a PowerPoint slide with this law of text, but the 2 other examples I'd like to give here is relate to digital access to court proceedings in criminal cases. And in 7 member states, as you can see, there is the possibility to have secure communication between defendants and defense lawyers to guarantee the confidentiality during hearings. In 6 member states, this possibility partially exists, and in 40, it's not currently possible. And then another example here is with regard to being able to initiate a case through digital channels or file an application, as well as to ensure further follow-up. And you have the data as well. I'm not going to go through this and read it. As I said, there are also a number of other aspects which the mapping explores, so you can take a closer look at it if you so wish. But here I get actually to the gist of it. How does this really link up to the RRF? Well, as explained in a very good level of detail by colleagues from SG Recover, the RRF is the key financial support instrument in the aftermath of the crisis. Well, it's still ongoing, which can support national digitalization reforms through both reform and investment action. In fact, I did, just prior to this meeting, I compared the overall budget of the RRF with the Marshall Plan. And it's interesting to note that, in fact, the total budget of the RRF is more than 6 times the expenditure budget of the Marshall Plan for Europe in 2019 prices. So it is indeed a unique opportunity to rebound from the EU effects of the crisis and move forward with these much needed reforms, also with regard to justice systems. As highlighted by colleagues in SG Recover, there is time is of the essence because all national governments need to submit officially their finalized plans by 30 of April this year. This is a legal obligation set out by the RRF regulation. This is where I am coming forward with my plea to you, because obviously legal professionals such as lawyers are an integral part of justice systems. If you have not been involved in this process, because I also know that in some member states there have been public consultations on the draft plans, but if you have not been involved in this process and are very much interested to see what your national government has in mind to propose, or have ideas which you think should be proposed for funding in the context of the RRF, please do take contact with your respective national authorities. Now, indeed, there is a focal point in each country, but I would say that in our specific case, your first port of call should be typically the Ministry of Justice, not ministers as they have here. And see with them what kind of measures are being proposed and what can be included, and also, of course, to take into account the needs of lawyers, because, for example, in some of the draft plans we have seen, and I cannot really talk about them, but some of them are quite ambitious. When we have integrated systems for electronic communication between actors, it should not be just courts and prosecution offices and the police, because lawyers are, of course, an integral part of this process. So I would very much like to invite you to take contact and see what's being drafted at the moment, because, as I said, again, time is of the essence. Colleagues have also highlighted the possibility to finance multi-country or cross-border initiatives. This is indeed the case also in our case. If you have ideas, you'd like to join forces and, let's say, work towards interoperable video conferencing systems for communication between different countries, that's just one example I can give you today. And with this, I will conclude my presentation. You have a few links here which are included for your reference, and I thank you very much for your attention.